members to operate in. And therefore, when we look at the good standing ratio, we were looking at combining the data from each of these different areas, as you see them on the map, and bring them into a central look as to how collections look in this particular area. So the second slide then has a look at the national good standing ratio of tenants in good standing versus the area of what we understand the JPOMA area to be. And as you can see, just before lockdown, the industry was collecting rent at around about 81.5% of tenants in good standing. That's the green line, and that had come off its height in 2013 of 86%. Coming into lockdown in the month of April, that deteriorated to 76%, and that was really just before a hard lockdown. So as you know, on the 1st of April, we were in hard lockdown, but the majority of tenants still had their rental collections. Or their incomes to make their rental collections. In the month of May, that dropped to 71.9. This is actually 71.96, rounded up to 72, 71.9 again. So really, the reality is that it's stabilized at this 72% of tenants in good standing nationally. And so far for the month of August, and remember, we're only 14 days into August, we're currently sitting at 62%. This 62% translate where we are month on month, day on day, where we are in the month at the moment. We expect that to creep up to the 72% mark. I don't really expect it to improve beyond that based on what we're seeing on a day-to-day position. So how does JPOMA look like? JPOMA was sitting at around about 78, 79% towards the end of last year. Coming into the beginning of this year, there was a deterioration and it stabilized at around about 74% of tenants in good standing. And just to remind everyone what a good standing definition is in TPN's definition. The good standing definition is the tenant who has settled their account in full. That means they've settled the balance brought forward on their account, the rent and all the utility charges by the end of the month. So they may be paid on time on the 1st when the rent is due, or they might have delayed payment right up until the 30th, the end of the month. But by that end date, that account is settled in full, including the balance brought forward. So 74% of tenants in good standing coming into lockdown. And you can see that the deterioration is far more significant in the JPOMA area than it has been nationally. So it's dropped right down from 74% to 52% in the month of May. And it's kind of stabilized at this 52 percentage of tenants in good standing. Currently for the month of August, sitting at 36%. And again, looking at the data, on a day-by-day basis, I expect that number to pop back up to around about the 52. So there'll be a stabilization at that 52. What is that telling us? Well, that's telling us even though that the economy is starting to open, and even though people a lot of people are back at work, we still have an enormous amount of individuals who have lost their income entirely. And if you look at, and this is, I found this report quite interesting, the BankServe had the take-home pay index, where they noted for the month of June, this month over here, almost 21% less consumers got paid an income this year than they got paid an income at the same period last year. So June on June. What was more interesting is where that loss was made up. So nearly 36% of people in the informal market, people who are earning weekly wages or daily wages, it was those 35% that were quite severely affected, whereas people that are earning monthly salaries, only 9% were affected, or there was only a 9% deterioration. And that might speak a lot to the type of tenants that sit within that JPOMA area, and why there's been a more significant deterioration in the JPOMA area. Right, I want to quickly stop share screen here, and I want to pop across to a different screen if I may. we go. Share screen. Okay. So this information here is something that TPN has been working on, and there's something very particular on this system that I want to share with you. So this is our property analytics portal, and what I've done is I've created the JPOMA areas as we had defined them in the previous map. So you will note they're all listed over here. I've specifically only looked at sectional title properties at the moment. And we've got average rent per square meter, the average value of the property, the good standing, and the yields. And so within the JPOMA area, I spoke a little bit earlier around the good standing. This good standing now, and I've just highlighted 4, so we've brought out Belleville, Berea, Hillbrow, and JP's Town. It is all preceding the lockdown, but you can see even within the JPOMA area, there are different areas that trend really quite differently. So this is Berea, and Berea was sitting in 2015 at 92% of tenants in good standing, and the deterioration just prior to lockdown was 77% of tenants in good standing. And compare that to an area like JP's Town, where in 2015, 62% of tenants were in good standing, and just before lockdown, that had already deteriorated to 56%. And I guess the story that I'm trying to, and I'm just going to take us one step further, because we can look at this across good standing, market value, so you can identify what is happening in the different markets, what your average rent per square meter is. But what I really wanted to talk about today was the good standing ratio, and I'm going to take us into JP's Town as an example, and I'm going to have a look at the data, and it takes a little bit of time to download because we really are now downloading the data live today as it looks today. And what we're seeing in the information is that even if you look at Johannesburg as a whole and you bring that down into the individual areas, there's different behavior patterns within the different rental brands within that particular area. So this is now the good standing ratio in the JP's Town area divided by the different rental brands. And we've got a 3-month average, a yearly average, and then we look at Johannesburg, Gauteng, and National. So you can see at JP's Town, the rentals where we have the most data is in rentals that are less than 3,000 Rand per month. We still have between 3,000 and 4,500. Then we have a lot of data again in the 4,500 to 5,000. Not so much in the 7 to 12. And then this would be commercial data. So we're going to ignore that for the moment. So you can see where the challenge is for tenants. It's in the lower value properties, in the less than 3,000. If we come to the 4,500 to 7,000 Rand rentals, you can see that the good standing ratio in the last 3 months, and I'm talking about the lockdown period. So you can see the effect of lockdown here in Q2. In the lockdown period, we still managed in that area to achieve a 62.67% good standing ratio. And the information there is then useful to say, okay, as a landlord, where are my properties and what is the value of the properties that we are managing? And are we seeing similar sort of trends within our data? Or we're looking to invest, what sort of properties have held their own in terms of the good standing ratio? Or where are the risks, and therefore how do we identify those risks, understand those risks, and mitigate for those risks? So Angela, I think the story is that yes, there has been a deterioration of rentals, more significantly good standing ratio, more significantly than there has been nationally. But there are pockets of excellence within the JPOMA area.
Thank you so much, Michelle. That's quite fascinating. That data is, I mean, it's quite, I think as a landlord or a developer, that data is quite invaluable. How would we be able to access those kind of analytics? Would you have to be a TPN member, or how would, if as a landlord, if I wanted to get access to that data, how would I be able to do it?
Yeah, so it's a subscription-based model, and we're happy to have a conversation with JPOMA as a whole, or landlords individually. It is literally live in the last week or so, Angela. So it's I'm only just honestly I'm showcasing it,
Okay.
just to share with you that there is such a wide variety of vast difference of how the data performs, even in something as simple as just a single suburb. In a broader area called JPOMA's area. Yeah.
Yeah. Well, thank you. Thank you. That is really fascinating. I just want to see if we've got any questions for you. No, we don't. Okay. Thank you, Michelle. I really appreciate it. And thank you for always being so willing to join us and give us this data. It is invaluable to us as property owners and developers.
My pleasure. Anytime.
Okay.
Thanks, Angela.
Thank you.
Cheers.
Bye. Okay, so now we're going to move on to the webinar. So we've got Mervyn Smith and his team here from MJS Attorneys. Mervyn has been in the industry for over 40 years. He is kind of the expert in a range of City of Johannesburg issues and matters. So Mervyn and his team do everything from billing, evictions, opinions, pretty much anything that needs to be done. But as far as the City of Johannesburg is concerned, he has a solid knowledge on how the city operates, how the billing team operates, legislative framework. So him and his team have been very kind enough to join us today to help us on the increase in the disconnection notices that we've been receiving. So I'm going to hand it over to Mervyn and his team. And if you have any questions, please put them in the questions bar so that I can pass them on to Mervyn and his team, Diana and Ethan. Thank you. Sorry, Mervyn, can you unmute?
Okay. Hello, Angela. Thank you for inviting us to share some information with you and your members. Just interesting from Michelle's statistics and to demonstrate how the collection of rentals has dropped. What we're going to talk about today or share with you is the fact that the council expects owners to sustain or maintain their payments for services rendered to their buildings. But clearly from the statistics, it is evident that owners are not able to, their income has dropped significantly and are unable really to, even if the debts or monies owed to the council are undisputed, they just haven't got the resources to pay the city. Now, when the regulations in terms of the Disaster Management Act were promulgated, one of the features was that no evictions could take place. Yet, the council was directed to provide services, which put us into a position where the owners were comfortable that their buildings would be serviced by the council, water, electricity, and it had nothing to do with the rent or the collection of money owing to the council was unrelated. What has happened subsequently is that the council, notwithstanding the regulations which prohibit them from suspending services, they are now proceeding. And although mention is made of notices, we have instances where they've in fact arrived at the building to cut services, and in other instances where they've actually cut the services. So what we're going to deal with, I think I'm going to, well, let me say this. I'm going to refer to Diana, who will deal with the situation as it presents itself with undisputed monies owing to the council, where the council threatens or cuts services on the basis of non-payment. The owner's response is, I don't have the resources, therefore I cannot pay you. The council nevertheless goes ahead and cuts. Ethan will deal, however, with situations where the council, even under these conditions, arrives to suspend services, where the owner responds, or his answer is that this debt is in dispute. You cannot cut, yet the council then proceeds to cut. So that's just an introduction, what we're going to deal with. As I say, I'm going to hand over to Diana, who's going to deal with the one issue as I raised, and Ethan the other, and then I will sum up after each presentation. Thank you.
Hi, everyone. I just want to do a screen share here. So obviously I'm dealing with the topic where the city comes to disconnect properties where property owners are finding it difficult to make payment of their utilities during this period. So subsequent to the lockdown announcement by the president, there have been several articles published. There's been directions published, as well as notices specifically by the CoJ, which deal with the situation. These notices, articles, and directions are unambiguous and undisputed, and it deals specifically with the way that municipalities, specifically the CoJ, should deal with the situation that we are currently facing. One thing that is important to note as I go through these various directions, notices, and articles is the wording lockdown, which we are still currently facing. The wording does not deal specifically with the 21-day initial lockdown period. It also does not deal only with certain levels of lockdown. So the first point that I will be discussing is the directions that were issued in terms of the Disaster Management Act. The first directive which was issued was published on the 25th of March, in which municipalities were directed to ensure that communities were provided with the necessary means to prevent transmission while preventing disruptions in services that are rendered through both municipal programs and customer interaction. Subsequent to these directions, there was an amendment which was published on the 3rd of July, which furthermore directed the municipalities to render specific services such as electricity, water, property rates, refuse removal, rental payments, and collections. So apart from these directives that were issued, and subsequent to the President's announcement of the 21-day lockdown period, the City of Joburg uploaded a customer service notice on their website during the month of, or it was immediately after the announcement, in which they undertook not to cut services during the lockdown period, which we are currently still in. The notice further indicated that the following actions will be suspended, of which there's the pre-termination notices, the final notices, and the disconnection of services in brackets, and this is directly as taken off from the notice, water and electricity services. So subsequent to the 21-day lockdown period, which was extended, there were also several articles published in which there were various announcements made by City of Joburg officials. So during May 2020, there was a media statement that was published on the City of Joburg website, which stated that the Councillor Matango, who is the MMC for Finance, assured residents that they will not disconnect services during the lockdown period. And this is in line with guidelines which came directly from the Minister of Cooperative Governance and Traditional Affairs. Subsequent to that article being published, there was a further article which was published on the 14th of July, in which the Director of Customer Communications of the City of Joburg was quoted to have said that the pre-termination notices which were issued since lockdown will not be executed in line with the COVID-19 regulations, in which they are not allowed to cut municipal services during the period. He further stated that at that time, there were no municipal agents assigned to attend residents' properties to disconnect the supply of water or electricity. He further then encouraged ratepayers to approach the municipality's credit control department for assistance with suitable relief measures where they are unable to pay their accounts. Subsequent to that article, and on the 4th of August, an article was published in the Alex News in which the MMC for Finance again quoted that the recent relief for this current pandemic includes the relaxation of credit control measures during the lockdown period. These relief measures which were set in place applied automatically to residential properties, whereas with multi-purpose residential properties and businesses, such owners need to apply for this additional relief. This again was published in an article on IOL on the 4th of August. It's an article, or on the 7th of August, it's an article which was published by Anna Cox, in which she again reiterated what was stated in the article of the 4th of August, which was quoted, or an article to have quoted what was said by the MMC for Finance, Councillor Matango. So yeah, Mervyn, I don't know if you want to just summarize that or if you want to go directly to Ethan.
I just want to add on to what you've said, Diana. Let's assume that, you know, despite all the regulations and the do's and don'ts and what the City of Johannesburg is directed to do or not to do, they proceed, and that, in fact, what they are doing is proceeding regardless. Then it's almost dismissive of whatever regulations bind them, that the attitude is they need to collect money and they don't care, they're cutting services. So where does it leave an owner where he's genuinely in a predicament? He has no money. He can't collect money from the tenants. He's not allowed to evict his tenants in order to bring in people who can pay, and yet he's still obliged to pay the City of Johannesburg. So that is the reality on the ground. So let's then assume that an owner is visited by City of Johannesburg officials to cut in those circumstances. Now, obviously, one has recourse to court generally, and you know, whether it's under normal circumstances, a disconnection for disputed debts, which Ethan's going to deal with, or under these circumstances where the council arrives to cut. There are certain legal issues which come into play, which under normal circumstances wouldn't. In terms of our common law, there are principles, for example, relating to impossibility of performance. It hasn't been tested yet, but in terms of an approach, a court could be persuaded that because of the circumstances that present itself in the country, because an owner is unable to collect his rental, aggravated by the fact that he can't evict anybody, he is prevented, literally, because of these circumstances, to pay for his services. So what one could do, which is we're busy at the moment developing in a current situation, a case to present to court, that we want the court to direct that the outstanding debt is suspended pending the outcome or pending the lifting of the virus regulations. But in the meanwhile, an interdict would be granted, preventing the council cutting the services. So it's a novel approach. It's something that we are busy developing and dealing with, and it's something that is certainly has a good chance of success. And the benefit of doing something like this is it will be, it's this particular matter we're dealing with is a small building, and it's the principle being that the owner cannot pay what he's due. He's paid regularly for the last 50 years. Now he cannot pay. If we are correct and the court gives such an order, it then establishes a precedent, because then any further steps that may be taken by the council in any other property, that precedent would be used in persuading any other court to grant relief on the same basis going forward. So that's really just to finish off Diana's points, and then we can I think we should suggest, or I suggest that Ethan give his presentation, and then we can tie everything up at the end. Ethan?
Thank you, Mervyn. And thank you, Angela, for this opportunity to present to your members. I've also made a PowerPoint presentation, and I'm just going to switch to that quickly. I'm just also going to stop my video for now while I do the presentation. So before we start, I just think that generally this is what we would advise clients to follow in the case of disputed accounts. The city of Joburg, prior to the lockdown during March, their track record with resolving municipal accounts was not great as it was. Currently, they're working on a minimized staff, and the expectation to have your accounts rectified or resolved has diminished more than it was prior to the lockdown. So like I said, this is what we would generally advise clients to follow, these procedures, in order to bolster any kind of case an attorney would need to proceed to court or to assist them in resolving their accounts. So as Mervyn said, I'm dealing with disputed accounts, and I'm going to proceed with the okay. So what to do immediately on becoming aware of an irregularity in the account or dispute. You should log the irregularity or dispute with the City of Johannesburg by writing an email to joburgconnect@joburg.org.za. The email should state to which account your dispute refers, provide as much information on the dispute as possible, and that the account is to be flagged, and no credit control action should be taken on the account pending the resolution of the dispute. Once the email has been sent, you should receive the following automatic response. Dear valued customer, thank you for contacting the City of Johannesburg. Kindly note that this auto response confirms that we have received your query. You will be provided with a reference number as soon as the query has been logged in your system, in our system. Kindly note that due to the impact of COVID-19, we are working with a reduced staff complement, which may impact the turnaround times. We apologize for the delay and assure you that assure you of our continued commitment. Now, before we carry on, I just want to inform everyone that it is unlikely that a reference number will ever be furnished in response to this mail. However, this automatic response is necessary to confirm the dispute was logged with the City of Johannesburg. Again, this helps any attorney in bolstering a case should the city come and illegally disconnect. The second thing you should do is obtain a reference number. As I said, the drafting of the mail to Joburg Connect, you will not receive a reference number. So to obtain a reference number for the dispute, you should log your dispute with the City of Johannesburg's call center. That is at 0860 Joburg or 0860562874. You should explain to the call center operator the dispute and to which account it relates. Ensure that the call center operator logs the dispute on the City of Johannesburg system for the relevant account number. And most importantly, ensure that the call center operator furnishes you with a reference number for the dispute logged, and record the date on which you receive it. Again, recording the date on which you receive it just helps the attorney to know, if you have multiple reference numbers logged, to know when they were logged and how often you are following up on your queries. Follow up on your disputes regularly. Keep records of all the correspondence between yourself and the City of Johannesburg, as well as all reference numbers obtained for your dispute. Follow up on your dispute on a weekly basis. This is what we advise. As, like I said, you need to build a case against the City of Johannesburg. In most instances, the city, especially with the reduced staff complement, will not attend to your query in any meaningful amount of time. If you receive no feedback from the City of Johannesburg on your dispute, you can escalate the matter by sending your dispute with the reference numbers to backoffice@joburg.org.za after 30 working days of logging your dispute on the Joburg Connect email. Then you can escalate it to backofficequeries@joburg.org.za after 7 working days of your mail to backoffice@joburg. Thereafter to escalations@joburg after about 7 to 10 working days of your mail to backoffice queries. Now, this is important. You must continue to pay your municipal account. The average monthly cost of rates and utilities prior to the reason for the dispute being raised should be paid to the City of Johannesburg until the dispute is resolved. Just going back to what Mervyn advised about the inability of landlords to actually pay the City of Joburg. We should at least try and pay something to the City of Joburg to show our good faith that we aren't just simply not paying, but this is all we can pay. Disputing the account does not entitle a property owner to stop making payments for services rendered by the City of Johannesburg, and failure to make payments to the City of Johannesburg at all will result in termination of services, for which the chances of success in an urgent application will be substantially reduced. What to do when a pre-termination notice is received? A pre-termination notice affords a customer 14 days within which to settle their account or enter a payment arrangement for the outstanding balance, or in the case of a disputed account, make a written submission where the outstanding balance on the account is disputed to Johannesburg Connect, call the City of Johannesburg call center, or attend to one of the City of Johannesburg walk-in centers. We advise that this must be done as soon as possible, as the City of Johannesburg are known to deliver pre-termination notices much later than the date recorded on the notice. We have had instances where the City of Joburg will deliver a pre-termination notice dated maybe 10 days before the date on which they actually deliver the notice, and then disconnect the next day. So that is the reason why we advise that you make the written submission to Joburg Connect as soon as possible. Due to the COVID-19 pandemic, the walk-in centers have closed. However, the steps to be taken are the same as those for logging a dispute. If you have already logged a dispute prior to a pre-termination notice being received, resend your mail previously sent to Joburg Connect with any reference numbers obtained and the pre-termination notice as well, just attached to the email. Your email must request urgent confirmation that the account is flagged. Thereafter, forward the mail to back office queries and escalations, and further any other City of Johannesburg representatives that you've been communicating with regard to a dispute, to ensure that your account is flagged and removed from the disconnection list. So if you have managed to secure a City of Johannesburg official who is working on your dispute, he or she is the person that you must immediately contact to ensure that your account is flagged and removed from the disconnection list, along with back office queries, escalations, and the Joburg Connect. Further, you should ensure that your building manager has a copy of your mails raising the dispute and any reference numbers obtained, and I'll explain this further a bit later. At this stage, and it is our advice that you enlist the services of an attorney to familiarize themselves with your dispute and assist with the resolution of the dispute. In many cases, accounts are said to be flagged, and a few days later, the building is disconnected of services, be it water or electricity. So if you have received a pre-termination notice, it is advisable that you contact your attorney and just let them familiarize themselves with the matter. Maybe, just maybe they should send off a letter or something just to the city to ensure that the account is flagged. What to do when the disconnecting official arrives at your property to disconnect? Disconnecting officials, especially independent contractors, are paid to disconnect services to the properties. These officials are therefore unlikely to entertain pleas that the account is disputed. We have had many instances where the account is disputed and the independent contractors or disconnecting officials do not want to hear any stories about that the account is disputed. So going back to why we say that that your building managers should have copies of all your reference numbers and emails sent to the City of Joburg, is that there may be a chance to delay these officials from disconnecting immediately if the building manager has copies of your emails raising the dispute and reference numbers on hand to present to the disconnecting official. If you are successful in delaying the disconnection, it is unlikely that the official will return later that day or the next day to disconnect unless he receives an instruction from the City of Johannesburg to stop any disconnection of services. If you are unable to get written confirmation from the City of Johannesburg within 2 hours that the disconnection must be stopped, we advise that you immediately contact an attorney to assist you and furnish them with the required documentation, which I will get to later. What to do once a CoJ has disconnected? You can try to contact the City of Johannesburg by email and phone to obtain an urgent reconnection at the property. However, it is our experience that the city will try to exploit the situation by requiring you to either pay the disputed portion of the account and obtain a refund after the dispute is resolved, or enter a payment arrangement inclusive of the disputed portion of the account. Obviously, this isn't advisable to go that route with the city and allow them to give you a refund later. In all honesty, it's probably not going to happen. We therefore advise that you immediately contact an attorney and provide them with the required documentation to quickly deal with the disconnection. The documentation required by attorneys should be regularly updated and a hard copy kept on hand in the event of any disconnection of services at the property. Documentation and information required by attorneys when handing a query over to an attorney. FICA documents to enable the attorney to quickly open a file for the matter. All correspondence between yourselves and the City of Johannesburg regarding the dispute raised. All reference numbers obtained for the dispute and dates on which they were obtained from the City of Johannesburg. A written breakdown of the disputes, obviously the more in-depth the better for the attorney. Copies of the municipal accounts related to the dispute. Preferably attorneys will want municipal statements from when the account was paid up to date until current, or from 6 months prior to when the dispute arose to current. Proofs of payment to the account for the last 6 months. Going back to what I said previously, it is good for us to say that yes, we are making payments towards the account, but this is all we can pay, or we are paying in terms of, for example, our independent meter readers if the meter is not reading correctly, or if, like I said, we just can't pay the full amount at this time. A copy of the pre-termination notice that was received, a copy of the disconnection card if it's applicable. Pictures of the meters showing the meter numbers with date stamps. If you can't get date stamps on with the camera that you're using, then I would suggest that you get a newspaper of the day, which has the date on the newspaper, and just put it next to the picture so that it shows that you took this picture on this day. Independent meter readers readings or check meter readings for meters at the property in relation to the dispute. Job cards for installation, replacement of meters. Application for split metering or tariff change, if applicable. And any other relevant documentation that would assist the attorney in building a case against the City of Johannesburg. As I said, this is not a comprehensive list of documents an attorney would require. It will obviously vary from case to case depending on what the dispute or query is. So, but this is a general list of documentations that's good to have on hand to quickly hand over to an attorney. And that is the end of my presentation. I thank you so much for your time, and I hand it back over to Angela.
Thank you so much, Ethan. Mervyn, is there anything you would like to add to that before we get into the questions?
I think let's deal with the questions, and then we can elaborate on anything that might arise from the answers.
Okay.
Sorry, can I just intervene? I think it's just important, you know, Angela, when we discussed this webinar and what you required us to touch on in the webinar, you did mention that you have previously advised the JPOMA members as to the process they need to follow prior or to log a dispute. And I think the reason, and it's important to note that the reason why we've again reiterated the steps to follow, is because the fact remains that when the City of Joburg official or contractor, especially an independent contractor, is at the property to disconnect, it is essentially already too late. So you cannot then, try and prevent the disconnection without following these steps that Ethan has gone through. So I thought, let me just highlight that again.
Thank you, Diana. Thank you. Yeah, it is important. I mean, I think my members are tired of me saying reference number, pay what you owe. These are important steps to protect yourself in the future.
And it's especially important, if the need arises to approach the courts, you obviously need to show the court your efforts and what steps you have taken to not only resolve the dispute, but also to avoid the current situation, being the need to approach court to intervene.
I mean, this is my question. I'm going to go through the questions now, but what if you have followed all the processes? Because we've seen it before where we have a valid reference number, paying the monthly, what we assume is the right amount, and then we still get a disconnection notice with the excuse of your reference number is now closed.
Yes. So look, this is our firm deals with a lot of these kinds of applications, where we have these queries logged, we've taken it up with the legal department, we've sent out letters of demand, and despite all of this, they'll either receive a pre-termination notice or without a pre-termination notice even being served, officials arrive and they merely disconnect. In some instances, you would have, it would merely take our officers contacting the City of Joburg, again, taking them through what was already done to try and resolve this dispute. But we've also had instances where the relevant person you would deal with would not actually entertain it, where they would say, look, I don't remember or I don't recall this dispute, and then we would go to court. Obviously, this is where all of your written correspondence and your reference numbers and all of that come into play. It is unfortunate that even though you have these queries logged, you followed all of the correct processes, that there's still a risk that your property could get disconnected. And if you cannot resolve it amicably with the city, then your only recourse is to approach the court.
And I suppose that's where the value comes in from specifically Mervyn Smith attorneys, is the fact that you guys have those already established contacts. You know exactly who to phone in order to resolve these issues and maybe prevent going to court, because you already have those established relationships with the guys in council, which is very important. Okay, so let's go for the... Yeah.
Sorry, Angela. Just one thing. Which in all our matters, when we approach the court for help, especially if we've managed to have the track record, sort of chapter and verse, all the correspondence, everything that we've done, in most instances, we get the court, we ask the court and we motivate why. The court would give us a punitive cost order against the CoJ. The effect of this would be that when we're successful with our relief, whatever that might be, to reconnect or to get an interdict, the court, and again, we argue and we get this, a punitive cost order against the City of Johannesburg. So when we draw and tax our bills, the large chunk of those bills, because I'm not going to talk about fees right now, but the client would recover most of his expenses incurred with the attorney to achieve the relief that he's asking for.
So I know you don't want to talk about fees, but I know I asked Diana this before. So in an ideal world, if you had to get an urgent application and all the paperwork is perfect, as Ethan has described, what kind of cost would a landlord look at to get his electricity reconnected?
Di,
Situation.
yeah.
Look, as I explained, it is very difficult. You know, even if you have your paperwork in order, it would also boil down to how complicated the query is. So, you know, and it would also depend on your disbursements, being your counsel in the event of making use of counsel.
Yeah, you see, just to add on from what Diana's saying, because we do this, this is one of the specialities that we do. You know, we draft all our papers. We don't necessarily use counsel in the drafting. We draft, if the matter gets opposed, we draft our reply. And we also, in probably most instances, argue the matter ourselves. So the disbursements are reduced or minimized dramatically. So the fees accordingly are reduced substantially. So the whole package where we have the fees, in a normal situation where you have fees plus disbursements to council, basically more than doubles the fees in that type of situation. In fact, the way we would approach it, we would do it at a far less sum of money, and with the prospect of recovering that money in our taxation when we succeed. So it could range. The other sort of issue is that in many instances the matters become opposed, which means that, you know, your costs are aggravated. So it could range from, you know, from 15,000, if not some less, or some more. It's just, you know, around that kind of figure. So that's basically where we at. Depends, as Diana says, the complexity, you know, but it doesn't, you know, it doesn't increase dramatically much more than that.
Okay, so let's go through some of the questions. Lendiwe from South Point, and this was based on Diana's presentation. She said that you made reference to water and electricity. Does this also, for that they're not allowed to cut water and electricity? And she also wants to know, does this include refuse? And would interest be charged on rates if they were outstanding? And she's, we know about the rates relief application. But if they have applied for the relief application and they're successful, would they then obtain credits or recoveries on their accounts? So it's quite a lot to unpack there.
Yeah. Okay, well, look, in terms of the question regarding refuse, so the directions state that the municipalities are directed to render services which include refuse removal.
Okay. So that answers,
And then let me just.
That would be the interest on rates.
If they were outstanding. One of these articles which I did refer to, I just quickly want to have a look. Can we come back to this?
Yes,
or can I?
Okay. I think with regard to the rates relief application, I'm dealing with that. So Lindiwe, I will find out that directly from Sihle, because I don't know if you guys would be able to answer that, if the rates relief would be backdated. So I'll find out that. Then Lindiwe said again, if we have a disconnection in lockdown, we would incur legal costs, but if we are successful in the dispute, would we be able to recover our legal costs due to the inconvenience caused? I think, Mervyn, you answered that really well.
Yes.
Then Vanessa, perfect. Has anyone been impacted in the change of sewer charge from block to multiple dwelling? If so, what now? So Vanessa, I'm going to park that question because JPOMA in the next 2 weeks is going to be doing a webinar on the new tariffs. We're going to be unpacking and going them into detail, the impact of everything. So I will send you an invitation for that and what JPOMA is going to be doing about the tariffs that we feel are a bit excessive. So that's going to be a whole webinar. I don't want to brush you off, but I think it's a very important question. and we will definitely cover it in our next webinar. Will we be sharing the slides from Diana and Ethan and Michelle? I'm sure you guys don't mind sharing your slides.
I have no objection. I can send that through to you, Angela.
Okay, that was from Lindiwe and Grace. Let me see. So this recording will be available on the JPOMA YouTube account. All of our webinars are being loaded up to YouTube. I will send out the link, but if you just search JPOMA on YouTube, you will get to our page. And all our webinars are being posted there. Then Riaz has asked, what can we do if a service has been discontinued, such as a water meter which has been removed a few years ago, and we are still being charged unestimated? This is specifically to water.
Yeah, well, look, we have dealt with a couple of those applications. Unfortunately, if you have not received any resolve to such a issue over a period of years, I would suggest that you would need to take it legal. You would need to consult attorneys, give them all the facts, and let them launch an application seeking the immediate rectification to the account.
Yes, if I could just add to that, like I said in my presentation, the city of Joburg, before this shutdown, their track record with resolving accounts was terrible. Now with the reduced staff complement, it's going to be even worse. So as Diana said, it's probably for the best that you take this legal, and that an attorney do an application to resolve this thing as soon as possible.
I see Riaz did mention that they have now received a letter of demand from the city's attorneys. So Riaz, as I would, as Ethan just said, I would recommend getting a lawyer involved from your side. Obviously, I suggest Mervyn Smith and his team, because this is what they do. So yeah, let me see, and they do have all the reference numbers and anything, and that is all the questions.
Sorry, Angela, before, I just want to get back. I can't get back to the first question, which I said I'd get back to.
There we go. Sorry, just look at, can you see questions and answers? I've put it under answered.
Oh, okay, have you, that's why.
So it was about interest being charged on the rates account if they were
outstanding. So in one of the articles which were published, the MMC for Finance specifically stated that with the relief for this COVID-19 pandemic, the relief includes waiving of penalty interest charges on defaulting municipal accounts. So he does not specify, for which services or which utilities interest charges would be waived. So I think it would be safe to assume that it is on the account as a whole, whether it be a default towards water or electricity payments, or whether it is rates which are owing. In my view, I don't know, Mervyn and Ethan, if you agree with me on that?
Yes, I do. Yeah.
Okay. I'll also double check that with Sihle, just to confirm when I ask her about the backdated relief. Lindiwe's asked another question, and she said, payment arrangements with CoJ attorneys insist on a 50% cost to be paid. Is this regulation?
Yeah. No. So that is what we've also experienced, and this is where we've also been approached by a lot of clients, is where either debt collectors for the city of Joburg or the relevant person who the owner is dealing with in the dispute turn around and demand payment of at least 50% of the total amount outstanding prior to even dealing with the issue at hand. They cannot do that, and it's been on that basis that we've launched applications, because in some instances the city has gone and disconnected, and they've refused to reconnect until the clients have at least paid 50%. And despite this demand, we have taken this issue to court, and we were successful, in which the judge has ordered that they had to reconnect immediately and deal with the disputes without needing to make payment of this 50% as demanded.
Yeah, I've seen that quite a lot as well. When I've taken members through to go and do acknowledgements of debt and anything, they won't even look at them without the 50%. So I actually thought that was regulation. So I've learned something new today. Okay, we've got more questions coming through. This is exciting. So Maria would like to know, she said she's noticed that on her August accounts, they've been billing interest, and she's seen a pre-termination billed as well. What would you recommend in a situation like that?
Well, if the account is disputed, and we can go to court and get an order for them to rectify that account. In that order, we would ask that any interest that accumulates on that account, or any pre-termination notices that are levied against that account, be withdrawn or basically recredited to the account.
I think what's also important here is, I don't think we've got quite enough information to advise positively. You would have to look at it, to see, first of all, did they receive this pre-termination notice? Was their query logged? What was the period of interest being charged? Is it for the period of August, or is it for a period prior to that? So I think a query of, to advise, yes, Ethan can give a general plan of action of what we would propose, but I think such a question would be tricky, and we would need to actually look into the details regarding that more closely.
Yeah.
Riaz has come back and said, would it be illegal to block a CoJ representative to disconnect if they are at our property to disconnect and we've logged a dispute with CoJ? Interesting question.
In what way would they mean block? That's also, again,
not allowing them on their property to disconnect. So if they come to disconnect and you just don't allow them to come into your property to do it.
To be honest, I wouldn't advise it. The CoJ officials, I believe, I think somewhere in the bylaws it does say that they are to be given access to the property, and even if the client didn't allow them access to the property, they have ways of disconnecting from outside of the property anyway.
Yeah, I just want to come in there. Look, I think, where they can enter the property despite opposition is in an emergency situation. I mean, if there's a fire, or if there's some event that takes place that warrants them like getting into the property, and your resistance or preventing them, they're entitled to probably break the door down. But if you merely lock the door and you don't allow them access, well, I mean, that's a factual situation. They can't break the door. I mean, if they try and gain access into the premises without a court order, then of course, they will be trespassing, they will be, malicious damage to property, whatever you want. You can lay charges against them. But, so to merely gain access, that means anybody knocking on my door, saying he's from the CoJ, even if he's got a visiting card, I mean, I'm not obliged to let him in. He's got to prove to me that, that there is, there's some justification, and his documentation's got to be right. And if I'm not happy with it, I'm afraid I won't let him into my house, and that should apply to everybody. But so whoever, I'm not sure who asked the question. I think, if you try and physically prevent him, that's a different situation. I mean, you don't want to do that. But to have the door locked and you don't allow him access, well, he must come back with a court order. That's my view.
Thank you. Then Prince has said, since we're still under lockdown, why are we being charged interest on arrears, or is it a specific period of time?
So in the article of the 4th of August, which quoted a statement from the finance minister or the finance councillor, he stated that interest charges were waived for the accounts between the period April and June. So beyond June, I'm not too sure, and prior to April, I would assume that the city is charging interest.
Okay. And then Clive has sent a question, and I know Clive well. I know exactly which matter he's talking about. So he's got a couple of queries that we couldn't resolve before lockdown, now virtually impossible during lockdown. He says that it's affecting their municipal bill, and in his experience, City of Johannesburg do not do fair adjustments on the accounts, and what is the best way for him to handle this?
Well, in my view, what I would advise, and from our experience also, with this COVID pandemic and the limited staff, to have matters resolved and to meet and try and negotiate and discuss the matters. I mean, even if you get a date to meet, to discuss, to try and resolve the issue, we've had instances where last minute the city has shut down because an employee has tested positive. So in the circumstances, and depending on how long he's dealt with the city, to try and resolve this out of court, I would advise the best option for him would be to approach attorneys, instruct them to launch an application, setting out his attempt to have the account queries rectified, and then to seek an order to have the account rectified as per, you know, how he says it should be. Obviously, you would need to provide proof and evidence of how he wants the account rectified and how he justifies that it should be rectified according to his opinion.
Okay, cool. I don't see any more other questions coming through. Oh, wait, no, another one. Samantha has come through. We have a building comprising of 535 units and council bills on residential resale electricity and resi for water. However, we have a much smaller building which council refuses to migrate to residential resellers and residential water. I'm just trying to see. Samantha, maybe you could just, she wants to know how does she resolve moving the building from, they refuse to migrate to residential resellers and residential water. So I think that they're being,
well, I think Andrew, we need to have a bit more information on that.
Specifically, the reason for the city's refusal.
Exactly. It would also depend. It would also depend on whether an application has been made to change from whatever the building is currently at to residential resellers. And as Diana said, has the city responded to that? Have they approved it? And if they haven't approved it, why haven't they approved it? These are all things that we would need to actually have a look at to make a determination on the way forward.
I think what I will do is when I send out the link to the YouTube and all the presentations, I'm going to put your guys' contact details there, and anybody who has been part of the webinar that would like more information or advice, then they can contact you directly. And, you know, I think that would be the best way, especially the more complicated issues.
Yeah.
Sure.
Okay. Is there, no, I don't think there's any more questions. And that it has been extremely informative. Thank you, Mervyn, Diana, and Ethan. I've really appreciated the time that you've given us today. And it's been, I've learned some stuff. I thought I knew quite a bit, but you know, you're never too old to learn. So thank you for that. And
thank you for having us, Angela.
Yeah, it was our pleasure. And you know, if we can help in any way, you just have to contact us. Thank you.
Great. Thank you so much. And thank you everybody who attended.
Okay. Thank you.
Bye-bye.
Bye.